This is in the 279th District Court of Jefferson County, Texas, and it's in the interest of Gillian Petrus. Ms. Alexander, this appears to be a motion to enter that you filed back in March.
Yes, Your Honor.
All right, your case has been called. You can call your first witness.
There's no witnesses to call. The state would enter the state's pay record. Oh, actually, no, my apologies. The state would enter the pay record in this case, Your Honor, as exhibit.
Mr. Brown, I've just placed State's Exhibit A on the record. Do you have any objection to that?
I don't. If I could see where we're at on the current pay.
Let me
the bottom.
Let me expand it a little bit, and then I'll bring it down for everybody to see. Is that better?
Yes, sir.
Ms. Wonders, do you have any objection to me looking at the pay record?
No, sir.
State's Exhibit A is admitted into evidence.
Thank you, Judge. And the state will call Ms. Wonders. Ms. Wonders, what is your full name?
Jennifer Ann Wonders.
Okay. Now, based on that pay record, as of June 30th, 2023, it does show that Mr. Brigden owes $25,869.80. Does that sound about right? I'm sorry?
Yes.
Does that sound? Yes, okay. And what is the name of the child before the court?
Gillian Petrus.
And what's Jillian's date of birth?
1/4/2000.
Okay, so Jillian's already aged out and graduated from high school, correct?
Yes.
Do you have any objections if the state asks the court to sign this qualified domestic relations order?
No.
No further questions, Judge.
Call your next witness.
The state would call Mr. Brigden.
Oh, wait. I'm sorry, Mr. Brown. I was on vacation last week, Mr. Brown, so you have to forgive me. I'm still trying to get back into the swing of things. Mr. Brown, you're witness on Ms. Wonders.
Thank you, Your Honor. Ms. Wonders, you recall when the Attorney General got involved, or when Mr. Brigden started paying child support, he was in arrears approximately $90,000 in 2012, correct?
Yes.
And at that time, the state required him to pay approximately $800 a month, correct?
Yes.
And since 2012, if we look at State's Exhibit A, what we're talking about is over 11 years ago. He has not missed a payment since then, has he?
I can't say if he has or not without looking at that.
But you wouldn't disagree with State's Exhibit A if it says he's never missed any payment, correct?
If that's what the paperwork said, I wouldn't disagree with it.
All right, and assume with me that in February of 2019, the record says he was approximately $82,000 in arrears. Do you recall getting a lump sum payment at that time of approximately $14,000?
And what year?
2019.
Yes, sir.
Okay. And you don't know where that money came from, but is it possible it came from a 401k?
It's a possibility.
Okay. And at that time, that took, if the records, if State's Exhibit A shows it went from approximately $82,000 in arrears to approximately $67,000 in arrear, you would not dispute that, would you?
No.
And then since then, you've continued to get the payments that are a little over $800 a month regularly, correct?
That's right.
And now the amount he owes you is down to, because he regularly pays, as State's Exhibit A says, about $25,869, correct?
That's right.
And you have, it's safe to say, you've been getting very regular payments since February of 2012, correct?
Yes.
I'll pass the witness, Your Honor.
Your witness, Ms. Alexander.
The state will call Mr. Brigden. Mr. Brigden,
Do you have any other questions of Ms. Wonders?
Oh, no, Judge. No further questions for Ms. Wonders.
All right, you may call your next witness.
The state will call Mr. Brigden. Mr. Brigden, what is your full name?
Donovan Luke Brigden.
Okay. And did you see the pay record that was put on the screen?
Yes, ma'am. It's hard for me to make it out, but I've looked at it on my computer.
Okay, and is it sound about right that you still owe $25,869.80 as of June 30th, 2023?
Yes, ma'am.
Okay, no further questions, Your Honor.
Your witness, Mr. Brown.
Donovan, you currently have a 401k, correct?
Yes, sir.
Do you have a 401k?
Yes, sir.
You know approximately how much is in there?
About 14,000, a little over 14,000, I believe. 14,300, something like that.
Are you currently contributing to that 401k?
No.
Now, back in 2019, did you have a 401k?
I did.
What happened to that?
Well, the state has taken it all and given it to Jennifer.
At the time, did they take 100% of it?
I think at the time they pretty much drained it all the way down to nothing. You know, there wasn't much left in it at all, if anything. But I was still contributing to it. So, you know, at that time.
At this time, do you have any other 401ks than the one you mentioned?
No, that's it.
Would you like to keep that 401k?
It would be great. That's it. That's all I have. And I'm 43 years old and I got 3 kids at home.
Do you intend to continue to pay down at the rate you're paying right now, this child support, until it's 100% paid off?
Absolutely.
And is that what you're asking this court to do, is deny the signing of this qualified domestic relations order?
Yes, I would greatly appreciate it.
And then you intend to keep paying this until you're totally paid off, correct?
Absolutely.
Since 2012, have you ever missed any payments?
No, sir.
I'll pass the witness.
Your witness, Ms. Alexander.
No further questions, Your Honor.
State rest.
The state rests and asks the judge to ask the court to sign.
Well,
the
let's see
court.
if Mr. Brown has any other witnesses. he wishes
Oh,
to-
okay.
Mr. Brown, do you have any witnesses that you wish to call?
No, Your Honor.
All right, so what I got here is I got a qualified domestic relations order, which my understanding of the new statute is basically doesn't give me a whole lot of leeway. That's your understanding as well, Mr. Brown?
I
You're breaking up, Mr. Brown.
but I think it could be denied.
Well,
Your Honor, you're frozen.
can you hear me okay, Miss Alexander?
Oh, I can hear you. Perfect, Judge.
Okay, I'm just making sure. I'm direct wired in, so it shouldn't be a problem. Mr. Brown, can you hear me?
I can hear you, Your Honor. I'm getting a sign that says host has stopped your video.
Right, yeah, it seems that I'm assuming you're on Wi-Fi, Mr. Brown? There, Mr. Brown?
I'm here, Your Honor, trying to get on my video.
Well, that's okay. Sometimes,
Okay,
are you connected by Wi-Fi, Mr. Brown?
I am, Your Honor.
So if you're using the local internet provider right now, they're having some issues with their Wi-Fi. So I have that issue at my house, but I'm hardwired in here at the courthouse, so I know I'm not having a problem. But the Wi-Fi is having some problems with Comcast at this time.
I apologize.
No, don't worry about that. That's one of the good things about Zoom. Sometimes they do have a convenience and sometimes they're an issue. So, Mr. Brown, I believe what I was asking you was, before we had our connection issue, was based on my reading of the current statute, I don't have a whole lot of leeway in regards to whether or not these are granted, but you believe that I do?
I just believe that the court has discretion on this under the circumstances.
Okay. Now, Mr. Brown, I do make it a policy in my court to always understand what my referring courts are doing. And this is a 279 district court. Is that correct?
Yes, Your Honor.
Judge Shelton has a pretty hard and fast rule that these are supposed to be granted on a pretty regular basis. I do have an alternative. Rather than giving the QDRO out. Ms. Wonders, can you hear me?
Yes.
Ms. Wonders, one of the things that I could do in this case is increase the amount of money that Mr. Brigden is paying you every month. And what I was thinking was, under the old statutes for withholding, that he would have to have this arrears paid off in 2 years with its interest, which would increase his payment that he owes you every month to $1,250. Would that be agreeable to you, Ms. Wonders?
Yes.
That would be, you'd be okay with that?
Yes, Your Honor.
All right, Mr. Rigdon, you're still under oath. Rather than take the money out of your account, I could increase what you're paying every month to $12.50. Would that be agreeable? Yeah, it's kind of tough, huh? That's $400 a month extra than what you're paying now.
Yeah.
Otherwise, I have to grant the QDRO, Mr. Rigdon, because you're supposed to have this paid off within 2 years. That's what the law said.
I guess. So we're at 800 and that it goes up to how much, Judge?
Right now, the pay record shows that you're paying $837 a month.
Okay.
Actually, the exact figure is $837.66, but I'd be increasing it to $12.50. So it'd be a roughly $413 a month extra you'd be paying to get this paid off in 2 years. And you'd probably pay it off a little faster than that. I added some wiggle room in there for the interest.
Okay. I guess that'll have to work, Your Honor.
You get paid every week?
No, I get, it's commission based, my wife commission.
Okay. And like most husbands, you probably don't know the exact amount of money that your wife is making, do you?
Sorry.
I couldn't tell you how much mine's making either.
It's-
All right. I think that's what I'm gonna do. I'm gonna deny the QDRO in this case, but I'm gonna increase the withholding to $1,250 a month. Obviously, Miss Alexander, you don't need my signature on a new withholding order for $1,250.
I don't believe we do, Your Honor. Those are administratively done.
Yes, ma'am. And obviously, the state always has the right to appeal if you wish to do so. It's in Judge Shelton's court. If you appeal it, he's probably going to overdo my ruling and issue the QDRO. That's basically been his rule of thumb. So,
And
but
that I do.
I do try to make, you know, I'll tell you all, I like QDROs. I think they're a great way for these big arrears cases, especially like Mr. Rigdon's, to get paid down quickly and help him get out from underneath the interest. But I do take into consideration the fact that Mr. Rigdon has been paying this money religiously for several years. I know back in the day, we didn't file QDROs when the obligor who was behind was paying the arrears faithfully, but they changed the statute. Now I think they're pretty much automatic, but that's the ruling of the court. Ms. Wonders, Mr. Rigdon, what's going to happen is they're going to issue a new withholding order. They are going to send me an order denying the QDRO. And the state of Texas, the AG's office does have the right to appeal my decision. If they wish to do so, they will send you a new hearing date on that. Okay.
Sir.
Mr. Brown, do you have any questions about my ruling?
I do not, Your Honor.
Is it okay, Mr. Brown, if I sign the denial motion without your approval?
Yes, Your Honor.
Okay. And obviously, as you know, Mr. Brown, Ms. Alexander's office has the right to appeal if they wish to do so.
We understand.
All right. Hey, I appreciate everybody's time this morning. I wish everybody the best of luck. You're all free to go.